Good morning, hey y'all. It's Miss FD here with my sidekick Levi the Golden Doodle to chat it up about civil liberties. Alright, Civil Liberties, Chapter 5. The Politics of Civil Liberties. Civil liberties are going to be defined as protections the Constitution provides against the abuse of government power. The framers believed that the Constitution limited government. State ratifying constitutions demanded the addition of a Bill of Rights. Remember, it was the anti-federalists here that believed in states' rights, and they refused to ratify the Constitution without a Bill of Rights. There they are, arguing about that. Okay, culture and civil liberties. The Constitution and the Bill of Rights contain a list of competing rights and duties. War has been the crisis that has most often restricted the liberty of some minority groups. Conflicts about the meaning of some constitutionally protected freedoms surround the immigration of new ethnic, cultural, and/or religious groups. Okay, here's a chart about immigration from 1840 through 1996. The immigration, this shows reasons for immigration, 1840, like I said, through 96 here. Potato famine, we had quite a significant number of immigrants coming here. And the vertical axis here, immigrants in thousands, so, you know, add 3 zeros. Economic panic going on during America. We had a drop here. During prosperous times, increase significantly. War, it's down. So if you look at the different events in history dealing with immigration, look at this huge spike here. So, huge increase in immigration in contemporary America. Okay, the 14th Amendment. Fabulous amendment. One of my favorites. Okay, 1868. The two big parts of the 14th Amendment are the Due Process Clause and the Equal Protection Clause. Due process says, no state shall deprive any person of life, liberty, or property without due process of law. And the Equal Protection Clause says, no state shall deny to any person without its jurisdiction the equal protection of the laws. And that does not apply to every group today. We're working on it. Okay, Supreme Court cases. Alright, and there was a case in 1897 that said no state can take private property without just compensation. That's called eminent domain. And then in 1925, there was this Gitlow case dealing with free speech. And does it apply to the states? Okay, they said federal guarantees of free speech and free press also apply to the states. What happened in the Gitlow case, Benjamin Gitlow was indicted and convicted for violating a 1902 New York Criminal Anarchy Act. And the prohibition applied to speaking, teaching, advising, printing, publishing, circulating, selling, distributing, or publicly displaying such doctrine. Gitlow had been charged with teaching the necessity and duty to overthrow the government in 2 publications. They were based on Karl Marx's Communist Manifesto. And what the issue was whether the First Amendment's protection of press and speech were included or incorporated. That's a big thing. Were they incorporated under the Due Process Clause of the 14th Amendment, thus making them applicable to the states? More specifically, they talked about subversive speech, and that's trying to overthrow the government. What the court decided was to uphold Gitlow's conviction, and so he lost on that. Palco case in 1937, certain rights must apply to the states because they are essential to ordered liberty, and they are principles of justice. These cases begin the process of selective incorporation. What's going on with the Gitlow case, that was in 1935. Gitlow broke into a music store and stole a phonograph. And he fled on foot, and when he was cornered by law enforcement, he killed 2 police officers and escaped. When he was captured a month later. So he goes to court. He was charged with first-degree murder, but instead he was convicted on the lesser offense of second-degree murder, given a life sentence. Prosecutors appealed the appealed the case, and they won a new trial. In the new trial, he was found guilty of first-degree murder and sentenced to death. Palco appealed that. Again, he argued that the Fifth Amendment protection against double jeopardy applied to state governments through the Due Process Clause of the 14th Amendment. So what happened was, when the court decided, they held that the Due Process Clause protected only those rights that were, quote, of the very essence of a scheme of ordered liberty, and that the court should therefore gradually incorporate the Bill of Rights into the states. Applying this subjective case-by-case approach is called selective incorporation. And so the conviction of Palco was upheld on the basis of double jeopardy, that it was not essential to the fundamental scheme of ordered liberty. So poor Palco murdered 2 people when he was executed in 1938 in the state of Connecticut.
Okay, so tell us what concept you're dealing with today.
We'll be discussing incorporation of the Bill of Rights to the states.
Why don't you explain that real fast for our students?
Sure. Originally, when the Constitution was written, the language technically only applies to the federal governments. So what that would mean is that while the national government could not take away, say, your right to free speech, the state of Arizona could.
Okay, so where are you seeing this play out in the news? What particular story?
Right. Well, it sounds like kind of a dry topic, incorporation, until you relate it to people being able to own a gun.
Yes,
and
that's an exciting issue.
And that is where we're seeing it now. Historically, many of the Bill of Rights have already been incorporated, like free speech, freedom of religion. But it wasn't until last week that the Supreme Court officially said that the Second Amendment right to bear arms, 2 things. 1, applies to individuals, and 2, limits state governments from taking that right away.
Okay, so prior to this court ruling, what did the law say about this issue?
Well, prior to this, that exact issue just had never come up to the Supreme Court. It had never been raised. So there were 2 competing theories. One said the Second Amendment meant that states could provide guns to state militias to prevent federal government from taking over a state. And the second interpretation said, no, it means that every citizen has the right to own a gun free from government prohibition. So the reason this issue came up now was Chicago, which, as you know, has a very high gun violence, essentially banned handguns without directly saying so. So the Supreme Court looked at the issue and said, the Second Amendment gives every individual the right to own a gun, and handguns specifically, because they're accessible to weaker people, smaller people, they're easy to use, and it's lawful to use a handgun for self-defense at home.
So with this federal Supreme Court ruling, does this mean anybody has an absolute right to own a handgun now?
Not necessarily. Good question. There have been gun demonstrations across the country to celebrate this ruling where people come and show their guns. But the Supreme Court was very clear to say they are not saying the state cannot regulate or limit the right to bear arms, but it just cannot absolutely ban an individual's right to own a handgun for self-defense at home. So notice how they phrased that.
Okay. So that's something contemporary issue with the Second Amendment. All right, libel. We've heard this before. It is a written false statement defaming another, as opposed to slander, which is the oral statement, oral version of libel. Public figures must also show the words were written with actual malice. And we've talked about malice before, and that is reckless disregard for the truth or with knowledge that the words are false. Okay, obscenity. How's the court going to rule in that? A while back in 73, courts defined obscenity based on the average person applying contemporary community standards to appeal to the prurient interest or to depict in a patently offensive way sexual conduct specifically defined by applicable state law and lacking serious literary, artistic, political, or scientific value. So they're basically balancing freedom versus decency and what the average person tests. That's what they used. Okay, symbolic speech. Okay. Cannot claim protection for an otherwise illegal act on the grounds that it conveys a political message, like burning a draft card. That was Schenck versus excuse me, U.S., or most recently Texas versus Johnson with the flag burning. That was the court said that was protected. The Free Exercise Clause of the First Amendment ensures that no law may impose particular burdens on religious institutions, but there are no religious exemptions from laws binding all other citizens, even if that law oppresses your religious beliefs. Some conflicts between religious freedom and public policy continue to be difficult to settle. Separation of church and state. Okay, the Establishment Clause. This is dealing with religion. Okay, come back. Government involvement in religious activities is constitutional if it meets the following three tests. Is it for a secular purpose? And what secular means is that it's not religious. Secondly, primary effect, it neither advances or inhibits religion. Another test, no excessive government entanglement with religion. The Establishment Clause. Okay, the exclusionary rule. This is going to deal with the court system, and that is the rule that evidence gathered in violation of the Constitution cannot be used in a trial, and that comes from the Fourth Amendment about unreasonable searches and seizures. The Fifth Amendment, I plead the Fifth. I'm not going to self-incriminate myself. That was tried in 61 in the case of Matt v. Ohio, and the Supreme Court began to use the exclusionary rule to enforce a variety of constitutional guarantees. Search and seizure. Basically, what can law enforcement look for and take? Alright, with a properly obtained search warrant, an order from a judge authorizing the search of a place and describing what is to be searched and seized, a judge can issue only if there is probable cause. And these are where law enforcement officers can look and what they have to have on their search warrant. They have to specifically say who's being arrested. They can search anything that's in plain view. Also, things or places under the immediate control of the individual. Alright, finally, terrorism and civil liberties. Since 9/11, things have gotten more strict as far as our civil liberties are concerned. The Patriot Act was passed, and that was meant to increase federal government's involvement to combat terrorism. An executive order then proclaimed a national emergency. Non-citizens believed to be terrorists or to have harbored a terrorist will be tried by a military court. Also under the Patriot Act, as you probably know, phone records, computer information can be seized without a warrant, and suspects can be held without for an unlimited amount of time. Alright, there you have it.